Now, here's another PJI attorney with their thoughts.
Thanks, Brad. Yes, this debanking is becoming a larger and larger issue, and I think it came to people's attention when President Trump issued his executive order back in August of 2025. And for those of you who aren't familiar, debanking is the process basically where a person or an entity is deplatformed or has their banking rights stripped from them. And so we think about what a necessity banking is, and it also involves a person to business or a business to business transaction or relationship. You go into a bank, you have, if you're an entity, legal documents that you must show the bank in order to prove to them that you are a legally accredited business that is allowed to transact business. So let's think about the nonprofit entities. You go in, you start your business and your banking relationship, whether it's with a credit union or a traditional bank. And if that bank were to have, let's say, extremely liberal views or views which were contraindicative of your views, and they decided they didn't want to have you as a customer, they could essentially take your banking rights away. They would debank you. Now, we've seen this happen with cryptocurrency and with other individuals who banks have dealt or deemed to be traditionally too risky for them. But lately, and as of late, it has come under fire for religious entities who are being debanked because of their religious views. Now, when you start to look at how few regulations there are related to this, you can see how risky this could be given political winds and how they may change for any religious nonprofit or individual for that matter to be debanked. And so for individuals, there's certain fair lending rights that have been enacted, but that only applies to an individual. Banks have great latitude in whom they can do business with because traditionally they are a place of public accommodation. But public accommodation laws, where you can't discriminate against an individual, apply to an individual. Once you enter the realm of business entities, whether for profit or nonprofit, there are not a lot of laws that regulate how businesses transact business one to the other. And so President Trump's executive order in August sought to put in protections around certain entities who were being debanked for no reason or little to no reason. And whether or not there is authority to do that, it's kind of on a bit of dubious ground, but it has gained a lot of traction in terms of what can and cannot be done, what banks are doing or credit unions are doing or not doing, and how they can freeze your funds or not do business with you based on political or religiously motivated reasons. And so some states ban discrimination. You've got laws, for instance, in Washington, where I am, we have anti-discrimination laws that are called public accommodation laws, the Washington law against discrimination, and those are throughout all the states for the most part. But again, that deals with individuals and their individual capacity to contract with banks. When it comes to other entities, it's a more slippery slope, as it were. And there isn't a lot of case law out there on this. What faith-based individuals and groups who are particularly vulnerable need to ensure for themselves is that they possibly have multiple banking relationships so that if they are debanked, they have somewhere else to go. What this also does is perhaps open up exciting opportunities for credit unions amongst nonprofits, where you can start to use those funds and band together for new opportunities. And I think oftentimes when issues like this come together, if the law is not going to protect these entities, whether it's churches, nonprofits, or just individuals, perhaps it's time to band together and to form a credit union or credit union network of our own. The other underlying factor is that, we have a larger regulatory body that governs banks. So you've got the Federal Reserve, you've also got the FDIC, and those are at the federal level. But what you have at the local level in every single state are the state regulatory bodies. Those are the bodies that regulate banking, and those are the bodies to whom each individual, whether on the individual level or at the nonprofit level, should go to if they are facing discrimination. And that really, those are the ones who audit banks. They come in and check the activities that banks are undergoing. There is an act called the Community Reinvestment Act that looks to how banks spend their money, what kind of clientele they have, and a variety of other factors that banks are sort of judged by or graded on for their involvement in their communities. And so, while there is not any one particular law that we have that governs this type of issue, there are myriad laws that sort of hedge in banks and credit unions that keep them from these types of discriminatory practices. There was one nonprofit in particular, the name is escaping me, but they recently were debanked. They had their funds essentially sent to them in the form of a check. And again, a bank is a private, semi-private company, and they can do business with whom they want. But to the extent that credit unions or other publicly traded banks are doing business with anyone, they have to do business with everyone. And so this really is going to start to test the laws that we have out there and whether or not you can refuse to do business with someone based on their political, ideological, or religious views.